Hello, my name is Mark Jones and I'm a partner in the Employment Department at IBB Law. The UK is currently in the midst of possibly the worst recession in more than 100 years. This has had an obvious impact on businesses and the way they navigate through these choppy waters. This video snip will focus on redundancy, employee representatives, and settlement agreements. In a recession, employers may be forced to make redundancies to cut costs and keep a business solvent, as employers are generally a business's most expensive asset. A redundancy situation may arise where the requirements of a business to perform work of a particular kind has ceased or diminished and could result in dismissals. In such a case, employers will need to comply with employment law to ensure that any resultant dismissals are fair. For example, a carrier airline, such as British Airways, is not making the same number of flights it did before the pandemic, and the requirement to perform cabin crew work on airplanes has diminished, giving rise to a redundancy situation. Where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, the employer must collectively consult about the dismissals of those employees placed at risk of redundancy at least 30 days before the first dismissal. As part of the collective consultation process, employees must consult with the recognised trade unions or existing employee representatives. If there are no representatives in place, then those employees at risk of redundancy are entitled to elect their own employee representatives, and employers must follow the statutory process. An employee representative's role is to represent the views and opinions of those at risk employees and act as a conduit between the employer and the employees. Employee representatives can, if they wish, seek employment law advice on the redundancy process and any payments that may be made to employees that are dismissed by reason of redundancy. Any employee that has been employed for a minimum of 2 years and dismissed by reason of redundancy is entitled to a statutory redundancy payment, which is calculated based on age, length of service, and capped at a maximum weekly amount, currently £538. If an employer decides to make enhanced redundancy payments above the statutory redundancy payment amount, employees may be required to sign what is called a settlement agreement. A settlement agreement is a legally binding contract between an employer and an employee, and the terms can be quite legalistic. In exchange for payment, the employee agrees, amongst other things, not to bring an employment tribunal claim against their employer in the future. It is a legal requirement that employees must take legal advice on the terms and effect of signing a settlement agreement. An employer will cover the legal costs in providing appropriate legal advice to the employees. In some cases where there are employee representatives involved, a single firm of solicitors can deal with all the settlement agreements of the employees. Employers like this, as any amendments to the employer's settlement agreement template can be agreed in advance, which creates consistency in terms. And the employer deals with one firm of solicitors and not multiple firms, which saves time and costs. Over the years, I have acted for hundreds of employees who have been given a settlement agreement, often multiple employees from the same employer. If you or someone that you know is going through a redundancy process, if there are employee representatives involved, and there is a requirement to sign a settlement agreement, I'm here to help. I'm Mark Jones, and thank you for listening.